Hello, my name is Lorraine Lee. I am the Chief Administrative Law Judge of the Washington State Office of Administrative Hearings. The Washington State Legislature in 1981 established our agency to provide citizens with an impartial forum to present their case and be heard in disputed matters with government agencies. Our mission is to independently resolve administrative disputes between citizens and state agencies through accessible, fair, prompt processes and issue sound decisions. The administrative law judges and employees of the Office of Administrative Hearings are dedicated to provide professional, competent, and high-quality services to everyone and all parties who appear before us. We hold ourselves to the highest level of ethical standards. Treating everyone with dignity and respect is our core value. In a year's time, more than 70,000 hearing requests are handled by the Office of Administrative Hearings. The great majority of these cases involve disputes that have a direct impact on the livelihood and well-being of the parties. We understand how important it is that these matters are resolved promptly. We are committed to issuing orders and rulings that are legally sound and well-reasoned, based on the evidence and information presented in the hearing and based on the relevant law and regulations. Our hearings are informal. Parties do not need to be represented by a lawyer. To help parties prepare for the hearing, this video shows what happens in a typical hearing held by the Office of Administrative Hearings.
Hi, I'm Jane Habeger, an Assistant Deputy Chief Administrative Law Judge with the Office of Administrative Hearings. We produce this video to help you prepare for and understand what happens during an unemployment insurance hearing. The hearing process is an opportunity for you to be heard. The hearing will be conducted by an impartial administrative law judge who is an attorney and is employed by the Office of Administrative Hearings, an independent agency not affiliated with the Employment Security Department. After conducting the hearing, the administrative law judge will make a decision about your case and will send the decision to you. Events leading up to a hearing might follow this pattern. First, a claimant who is a worker who becomes unemployed goes to the Employment Security Department to apply for unemployment benefits. This can be accomplished in person, over the telephone, or on the internet. Next, the Employment Security Department reviews the completed application and issues a determination notice, which is a decision regarding whether the worker claiming benefits is eligible for unemployment insurance benefits. The determination notice is sent to both interested parties, the claimant and the claimant's former employer. A determination notice may grant or deny unemployment benefit payments to claimants. If either the employer or the employee disagree with this decision, they can ask for a hearing. Then, the Office of Administrative Hearings will mail both the claimant and employer a notice of hearing setting a hearing date. All parties will receive copies of the exhibits prior to the hearing. These documents will also be submitted to the administrative law judge. Preparation is key. Take the time to review the documents for your hearing and to think about what you want to tell the administrative law judge and what you want to ask the other party and witnesses. You can fax additional documents to the administrative law judge at the fax number on your notice of hearing and to the other party, or you can bring additional documents to your hearing. You can also bring witnesses to your hearing. You may be represented by an attorney or someone else, such as a friend or a family member. If you would like legal representation and can't afford a lawyer, you can call the Unemployment Law Project to see if you qualify for their services. Most hearings occur over the telephone. The administrative law judge conducts the hearing over the phone with the employer and the claimant appearing by telephone from different locations, such as their home or place of business. The notice of hearing contains instructions on how to call the administrative law judge for your hearing. It's very important that you call in on time for your hearing, or your hearing will be dismissed. The hearing you are about to see, however, is an in-person reenactment of an unemployment insurance hearing. The mock hearing participants will be Judge Bill Williams as the administrative law judge, Laura Jackson is the employer's hearing representative, Allison Smith is the unemployed worker or claimant who filed an application for unemployment insurance benefits. She is appealing the Employment Security Department's decision to deny her unemployment benefits. Catherine Jones is Ms. Smith's former supervisor at Acme Fireworks, and Alvin Robinson is the human resources representative at Acme.
Good morning, Your Honor. Where would you like the parties to sit?
Good morning. The employer can sit on this side, please. And Ms. Smith, if you would, have a seat over here. Hey, good morning. This hearing is being recorded. The hearing will now come to order. We're here in the matter of Allison Smith, claimant for unemployment benefits. Docket number is 01-2010-26200. My name is Bill Williams. I'm an administrative law judge with the Office of Administrative Hearings, an independent agency in the state of Washington. I am conducting this hearing here at the Office of Administrative Hearings in Olympia, Washington. All of the parties are appearing in person. Today's date is July 15, 2010, and it is now approximately 10 a.m. Present is the claimant, Allison Smith. Ms. Smith, would you state and spell your name for the record?
Allison Smith, ALLISON Smith.
Thank you. The interested employer in this case is Acme Fireworks Incorporated, being represented by Ms. Laura Jackson, their hearing representative. Ms. Jackson, would you state and spell your name for the record?
Laura, L-A-U-R-A, Jackson, J-A-C-K-S-O-N.
Also present are the employer's witnesses, Ms. Catherine Jones, a supervisor at Acme Fireworks, and Mr. Alvin Robinson, the human resource manager. The Employment Security Department did not send a representative to today's hearing. Ms. Jones, could you state and spell your name for the record?
Yes, Catherine Jones, C-A-T-H-E-R-I-N-E, Jones, J-O-N-E-S.
And Mr. Robinson?
Alvin Robinson, A-L-V-I-N-R-O-B-I-N-S-O-N.
I will administer the oath to those witnesses whose testimony I expect to hear today. So Ms. Smith, Ms. Jones, and Mr. Robinson, please raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Ms. Smith?
Yes.
Ms. Jones?
I do.
And Mr. Robinson?
I do, Your Honor.
Thank you. There are two issues in this hearing as reflected in the hearing notice, the first of which is whether the claimant was able to, available for, and actively seeking work, and the second issue is whether the claimant voluntarily quit without good cause. Under the Employment Security Act, an individual who quits their job without good cause, as defined by the statute, is not entitled to unemployment benefits. Likewise, an employee who gets discharged or fired for some type of misconduct connected with work, as defined by the statute, is not eligible for benefits as well. The purpose of the hearing is to allow the parties to present evidence in the form of testimony or documents, and we will be establishing a record of today's proceedings. On the notice of hearing, you'll find your names and addresses. Please check those now to make sure that we have the correct information. If not, please let me know. The Office of Administrative Hearings sent out a packet of exhibits along with the notice of hearing. I'd like to go through the exhibits now in preparation for their admission into the record. Exhibit number 1 is a notice of hearing dated June 29, 2010, containing a total of 2 pages. Exhibit number 2 is the determination notice issued by the Employment Security Department on June 1st, 2010, and that contains a total of 5 pages. Exhibit number 3 is the notice of the appeal being filed, and that contains a total of 3 pages. And Ms. Smith, on page 3 of Exhibit 3, I see what appears to be a signature. Is that your signature?
Yes, it is.
And did you write this letter?
I did.
And everything you say there true and correct to the best of your knowledge?
Absolutely. Everything I wrote is the truth.
Exhibit number 4 is a notice to employer claimant's separation statement containing a total of 6 pages. And on page number 2 of Exhibit 4, Mr. Robinson, appears to be a signature. Is that your signature?
Yes, sir, it is.
And there are handwritten notations on pages 1 and 2. Did you make those notations?
I did.
Is everything you said there true and correct to the best of your knowledge?
Yes, sir, it's true and accurate. I completed the form myself.
Thank you. During the hearing, the parties will have an opportunity to object to evidence, including testimony on the record. Some objections might be because the evidence is not relevant. Another objection might be because the evidence is repetitive. In other words, we've already heard the testimony on that issue. Ms. Smith, do you have any objection to the admission of Exhibits 1 through 4?
Yeah, on Exhibit 4, I don't like what they said. Mr. Robinson doesn't know anything. He wasn't even there. He works in an office on the other side of the building.
Okay, Ms. Jackson, would you care to respond?
Your Honor, I think the document is relevant and should be admitted.
I'm going to overrule the objection. I will allow the document into the record. Ms. Smith, during your testimony, you can raise information to refute the statements in that document, and as well as ask the employer questions about that document during cross-examination.
That's fine. I know exactly what I'm going to say. Sorry.
Now, Ms. Smith, any other objections to the admission of Exhibits 1 through 4?
No objections.
And Ms. Jackson, any objections to the admission of Exhibits 1 through 4?
No, Your Honor.
And there being no further objections, let the record reflect that Exhibits 1 through 4 are so admitted. And before we begin, any questions on anything we've covered so far?
No questions. No, Your Honor.
First, I will have a few questions for Ms. Smith regarding her availability and search for work. Ms. Smith, during the time that you've been claiming benefits, have you kept a job search log?
Yes, I filled out the form that Employment Security Department sent me.
And during the time that you've been claiming benefits, what would be the fewest number of job search contacts you would have made in any given week?
I've applied for lots of jobs. I applied at Tony's Restaurant. I applied at the Rack in
Ms.
the
Smith,
mall.
hold on, Ms. Smith. I don't need to know all of the jobs you've applied for right now, but during the time that you've been claiming benefits, what would be the fewest number of job search contacts you would have made in any given week?
I always do at least 3.
And Ms. Smith, during the time that you've been claiming benefits, have there been any limitations on your availability?
Well, there aren't any jobs available.
Well, I understand. During the time that you've been claiming benefits, if you were offered a full-time job, would you have been able to accept it?
Oh, definitely.
Okay. Thank you. I don't have any further questions for Ms. Smith on this particular issue. We will be talking about your job separation in a few moments, but before we do, Ms. Smith, is there any other testimony you'd like to tell me about your job search or your availability?
No, Your Honor.
Ms. Jackson, do you have any questions for Ms. Smith on the issue of her availability?
No, Your Honor.
Thank you. Okay, now with regard to the job separation, I will hear the claimant's case first, as she is the appellant having been denied unemployment benefits. The Employment Security Department adjudicated this case as a voluntary quit, in which case the claimant, Ms. Smith, has the burden of proof.
What is that exactly, Your Honor?
The burden of proof is a legal term that refers to the responsibility of a party to prove their case. The party with the burden of proof must produce evidence to convince the judge about the underlying dispute. In the case of a voluntary quit, it is the claimant who has the burden of establishing and proving their case. Is that clear?
So, does that mean that I have the burden to prove that I left my job for a good reason?
Yes, you have the responsibility and the burden to prove that you had good cause to quit your job. And now we'll begin with the testimony. Ms. Smith, how would you like to proceed? Do you have a presentation prepared for me, or would you prefer that I ask you questions?
Go ahead and ask me questions, Your Honor.
Hey, Ms. Smith, what was your job position at Acme Fireworks?
I worked in the factory on the assembly line.
In what city?
Renton.
And when did you start?
About 7 years ago.
And was this a full-time position?
Yes, 40 hours a week, Monday through Friday, 8 to 5.
And who was your supervisor?
Catherine Jones, certified jerk. Excuse me, she was my supervisor and chief jerk.
Okay, I want to remind all the parties to be respectful in their presentation and testimony. This is an informal hearing which allows you, as well as the other party, the opportunity to present their case.
I am respectful, Your Honor. I'm sorry. I will try and tone it down.
Hey, Ms. Smith, what was your last day of work?
It was in May. I remember that day. I wish I didn't. It was a really bad time. It ruined everything.
Was that 2010?
Yes.
Your Honor, for the record, Ms. Smith's start date was in July 2003, and her last day of employment was May 14, 2010.
Thank you, Mr. Robinson. I realize you're trying to be helpful, but please wait until it's your turn to testify.
Oh, my apologies, Your Honor. I will.
Okay, Ms. Smith, how did your job end?
They fired me. I don't care what they say. They fired me, pure and simple. 7 years of hard work. And it's over in an hour. They just pushed me out the door like I was a piece of trash.
Did they give you a reason?
They said that I refused to take a drug test.
When?
Asking me to take the drug test?
Yes.
The same day they fired me.
And can you elaborate and explain the circumstances?
Well, it was a Friday. I remember I wasn't feeling too well. I usually didn't at the end of the week. I was tired, worn out. Anyway, I came in to work on time. I punched in. I was putting my apron on. I was getting ready to go out on the line. when my supervisor comes up to me and says, "Allison, you have to go for a random drug test." I said, "What for?" And she said that my name came up random. I told her that she can't do that. And she says, "Yeah, we can." I told her she couldn't make me. And she said, well, it was up to me. If I refused to take the drug test, that I would be fired. And then she said that if I didn't take the drug test, that I would be quitting. I told her that was totally unfair. And then she said, well, then you're done. Turn in your badge and your keys, and they'll process your paperwork up front. I sure as heck took that to mean that she was firing me right then and there. So I left.
Is there anything else you'd like to tell me about your job separation?
Yeah, I don't think them trying to make me take a drug test is even legal.
Is there anything else you'd like to tell me at this time? Keep in mind you'll have another chance to testify later.
No, Your Honor.
Hey, Ms. Jackson, do you have any questions for Ms. Smith?
Yes, Your Honor. Indeed, I do.
Please proceed.
Ms. Smith, is it true that you came to work drunk on the morning of May the 14th?
No, that is a lie.
Is it true that you also stumbled as you came through the door?
Yeah, but only because some lazy night crew person left wood lying in the threshold. I didn't see it.
Isn't it also true that you smelled of alcohol and your coworkers noticed it?
I wouldn't know if they did. Nobody said anything to me about it. I was just told by my ridiculous supervisor that I had to submit to a drug test and that it was random. Random. Yeah, right. I do remember that I had just gargled Listerine right before I came in, and I used cough drops. Like I said, I wasn't feeling good. I keep a supply of both those things in my car for emergencies.
And you were well aware of your employer's drug testing policy?
No, ma'am. I'd never heard of it, never saw any paperwork on it. That policy is a mystery to me. That's why it pissed me off so much when they told me I had to go take a random drug test.
Okay, Ms. Smith, we need to maintain professionalism here, so I'll ask you again to use respectful language.
I'm sorry, Your Honor. This whole thing just has me so worked up. What they did to me is unfair and wrong.
Objection, Your Honor. I move to strike that comment as irrelevant, non-responsive, and potentially prejudicial.
The objection is overruled. I will give the statement the proper consideration. Ms. Jackson, please continue with your cross-examination. Any more questions for Ms. Smith?
So, Ms. Smith, you refused your supervisor's direct order to submit to a drug test.
I didn't refuse, and I wasn't insubordinate. I was in the military in Iraq. I know you can't disobey a direct order. I was simply expressing my belief that it was unfair, which it was. I was using my First Amendment rights in saying so.
So when you went to turn in your keys, you didn't offer to take the drug test then, did you?
I didn't refuse to take the drug test. It's true I didn't want to do it, but I would have taken the test. They didn't give me a chance. They fired me instead.
So when you were turning your keys in, you could have offered to take the drug test then, but did you?
How could I? I was already fired at that point.
All right, I'm done with this witness.
Okay, Ms. Smith, do you have anything further to add by way of redirect?
What's redirect?
That's your chance to speak again if you'd like to.
I don't even see what the point is. You're just going to believe whatever they say anyway. This whole thing is a joke.
All right, Ms. Smith, that's enough.
Came.
I'd like to reiterate the ground rules for maintaining a professional and respectful hearing. This forum provides an impartial hearing to both claimants and employers to present their case. I have not made a decision in your case. I intend to hear from all of the parties, consider all of the testimony, and review all of the evidence before making my decision. That's how I'm going to proceed. Do you have any further questions?
No, Your Honor.
And now we will hear from the employer's case.
I call Ms. Jones. Ms. Jones, you're employed with Acme Fireworks.
Yes.
And how long have you been there?
6 years.
And what's your title?
Supervisor.
Did you supervise Ms. Smith?
Yes, I did.
And were you at work on the day of May the 14th?
Yes.
Did you have an encounter with Ms. Smith?
Yes.
Can you tell me about it?
I came to work at 6 a.m. At 8 a.m. I was near the door. Miss Smith always used to use it's near the time punch clock. I saw her come in and stumble through the doorway. It smelled something really bad, like alcohol. It seemed to me she might have been drinking before coming to work. We have a drug-free workplace and zero tolerance for the use of any drugs or alcohol.
So what did you do?
Well, I called my boss, the plant manager, Mr. Jameson. I told him what I saw with my own eyes. He advised me to call Human Resources.
And did you call Human Resources?
Yes, I called Mr. Robinson. I told him what I'd seen, and he advised me what to do.
And what did he say?
He said I should direct Miss Smith to go to our drug and alcohol clinic for a screening. That's standard procedure for anyone under the influence.
And what happened next?
Well, I hung up and walked over to Miss Smith and told her that she had to take a drug test.
And then what happened?
She asked why. She asked a number of times. I told her you just have to go for a random drug test. That wasn't good enough for her. I repeated that she had to go, and she said she's not going to go.
And what was her response after that?
Well, she just refused to go. I couldn't believe her attitude. She swore. She used the F word. That's totally out of line. Next thing, she just storms out. I figured she'd rather quit than take the test.
And what happened next?
Well, I reported to the Human Resources Manager everything that happened.
That's all the questions I have. Is there anything else you'd like to say, Ms. Jones?
No.
Okay, Ms. Smith, do you have any questions for Ms. Jones?
Yeah, I do. Why are you lying about our last conversation? That is not what happened.
Excuse me, Ms. Smith. Your last sentence was a statement. Can you perhaps rephrase it as a question?
I'm sorry. I meant to ask, why are you lying about our last conversation?
That's how I remember it.
Then you have a lousy memory.
I have no problem with my memory. You're the one with the drinking problem.
Okay, Ms. Jones, you need to be respectful as well. And a reminder to all the witnesses, you need to direct your answers to me. Ms. Smith, any more questions?
No, I'm done with her.
Okay. Ms. Jackson, do you have another witness?
Yes, we'd like to call Mr. Robinson.
Yes.
Mr. Robinson, please remember you are under oath.
Yes, sir, I do remember.
And please continue with your questions.
Mr. Robinson, what's your occupation?
I'm the Human Resources Manager at Acme Fireworks.
And how long have you worked there?
4 months.
Do you know Miss Smith?
No, not personally. We hadn't met before the job separation.
Did you process her separation paperwork?
I did process it myself, yes.
Was Miss Smith discharged? Did she quit? Was she laid off for lack of work, or was there something else?
Oh no, she quit.
Was the job separation documented?
Yes, it was.
What did you do?
I wrote a statement, which is here in Exhibit 4. Based on what Ms. Jones told me, I wrote that Ms. Smith apparently abandoned her job after she was instructed by her supervisor, Ms. Jones, to submit to a drug and alcohol screening.
Ms. Jones testified that she consulted you about certain observations that she made that morning. Was that true?
It is true. She told me that she saw Ms. Smith stagger into the doorway when she was coming to work for her shift, and that she smelled of alcohol.
Anything else?
Not that I can recall, no.
Did Ms. Jones report to you in person?
No, she telephoned me from the plant.
And did you document that conversation or write a report about it?
No, but I remember pretty well. It was my first termination at Acme, and I'll always remember that one.
Does Acme Fireworks have a drug and alcohol policy?
Oh, absolutely.
And what is that policy?
That policy is that if you come to work drunk, you're fired, and that's the way it should be. We run a big operation, and we need to think about the health and welfare of our employees and our business.
Did Ms. Smith report drunk to work on the day of May 14, 2010?
Yes. From what I've been told, I do believe she was drunk.
And what is Acme's testing policy regarding drugs and alcohol?
Well, we can require testing whenever there's suspicious behavior in the workplace. It's an inherently dangerous job, and we have many high-speed machines on the assembly line. We have many vehicles delivering materials here and there throughout the plant. The product itself is highly explosive, and so if anybody is impaired or under the influence, somebody can get seriously hurt.
And so how does that testing policy work?
Well, we can send any employee who appears to be impaired off to be tested, and we occasionally conduct random tests on employees. Everybody agrees to this as a condition of continuing employment with the company.
Is that policy written down?
Do you mean if it's in a handbook?
Yes.
Well, we don't have an employee handbook, but we do cover the policy during job orientation. Everybody knows about it.
Is that policy written down anywhere?
Well, let me see. I'm not sure. I would have to check my files.
About how long would that take?
I might be able to contact my office right now. I could have it to you by tomorrow, and I'd be able to fax it to Ms. Smith as well.
Your Honor, may we take a break at this point? This will give my witness a chance to call the office and have someone search for the files for a document which I think is very relevant and you would find very helpful.
Your Honor, I object. They've had many weeks to prepare for this hearing. The pamphlet that you sent to us said that we have to have our documents in before the hearing. It's not fair to let them go on a fishing expedition now. They don't even have a written policy. They're just going to go make one up.
Ms. Jackson, would you care to respond?
Acme was having technical difficulties accessing files on their computers, and we'd like to take the opportunity now to find the document and present it.
I'm going to overrule the objection. If the document exists, it would be important to have it included in the record. So why don't we take a short recess? We'll go off the record and be back in 10 minutes. All right, we're back on the record, and while we were off the record, we did not discuss this case. Is that correct, Ms. Smith?
Yes.
Ms. Jackson?
Correct.
Ms. Jones?
We didn't talk about the case.
Mr. Robinson?
That's correct. There was no discussion of the case.
Ms. Jackson, please continue with your questions for Mr. Robinson.
Thank you, Your Honor. Mr. Robinson, was your office able to find Acme's drug and alcohol policy?
No, they haven't, but I know it's there somewhere.
Your Honor, we request that Mr. Robinson be allowed more time to provide Acme's drug and alcohol policy.
Your Honor, I want to object to that too. You just gave them time to find it, and they couldn't find it because it doesn't exist.
I already ruled on that objection. I will keep the record open until 5 p.m. tomorrow to let the employer produce the document.
And I'll bet that they won't find it. But if they do, I want to see it.
Any documents that are sent to the administrative law judge must be sent to the other party as well. I will keep the record open until 5 p.m. tomorrow to allow the employer to produce the document. If they do produce the document, Ms. Smith, you will have one additional day to respond. If they do not produce the document, I will go ahead and issue my order. Let's continue. Ms. Jackson, any other questions for your witness?
No other questions, Your Honor.
Ms. Smith, any questions for Mr. Robinson?
No, I don't. He doesn't know anything. He met me the first day that I was fired. If I ask him questions, he's just going to make up a bunch of baloney like he is about this policy.
Okay, Ms. Jackson, anything else from the employer's case at this time?
No, Your Honor.
Ms. Smith, do you have anything you'd like to add at this point?
I have a few things to say, Your Honor, but they can wait for closing statement.
Ms. Jackson, would you like to make a closing statement?
Yes, Your Honor. The employer's credible testimony has established that it placed a reasonable requirement on the claimant that she submit to a drug test. This was based on a good faith, reasonable belief that she might be impaired. And this was also in keeping with Acme's zero tolerance drug and alcohol policy. But rather than submit to a test, the claimant chose to abandon her post and to quit. And she left voluntarily. She was not fired. And she did not quit with good cause. That's all.
Ms. Smith?
Thank you, Your Honor, and thank you for carefully listening to all of the testimony today. They have no drug policy. My supervisor put a bogus requirement on me based on nothing. She just doesn't like me. I don't drink and I don't do drugs, and I am insulted that they would suggest that I looked impaired because I tripped over a piece of wood lying in the doorway. I did not tell Ms. Jones that I refused to take the drug test. I was simply exercising my First Amendment rights and telling her that I didn't think it was fair. She's lying when she says that I quit and walked out. And she also left out the part where she told me to turn in my badge and my keys. That's all, Your Honor.
Anything further, Ms. Jackson?
No, thank you, Your Honor.
Just a reminder to the parties, I will keep the record open until 5 p.m. tomorrow. And if the employer does produce the policy, Ms. Smith will have one additional day in which to respond. If I do not receive the policy, I will go ahead and issue my order. Ms. Jackson, you understand that whatever you provide to me, you must also provide a copy to Ms. Smith, correct?
Of course, Your Honor.
Thank you. I will determine whether further proceedings are necessary. Before we adjourn, I would like to explain your appeal rights in this particular matter. I will be issuing a written decision, and every party will have an opportunity to appeal that decision by filing what's called a petition for review.
Your Honor, how long does it take you to write your decision? I mean, this isn't easy for my family, and I'd really like to get my benefits as soon as possible.
Thank you for raising that question. I appreciate your situation and the need to have a decision rendered quickly. My written decision is called an initial order. I anticipate it will be in the mail to you within 5 business days or less. When you receive it, I encourage you to read it thoroughly. If you disagree with my findings of facts or conclusions of law, you may file an appeal with the Commissioner of the Employment Security Department. That appeal must be filed within 30 days from the date of the mailing of my order to you. There will be instructions at the end of my order concerning the appeal and the address where you need to mail it. Thank you for your participation today. Ms. Smith, good luck with finding employment. This hearing is adjourned.
Thank you, Your Honor. Thank you, Your Honor.
For further information, please review How to Prepare and Present Your Case, Unemployment Insurance Appeal Instructions and Information. This brochure is mailed with your notice of hearing. In it, you will find valuable information that may help you to prepare for your hearing. Our website also has helpful information. Please visit www.oah.wa.gov and select Unemployment.